on the Mason faculty contributed to this book. The number is 8, which is more than any other school in the country by a factor of like 3. Please clap. Please clap. It really is amazing. So for the first panel, I have 3 friends and colleagues I've gotten to know so well over the years, and they will be talking about the essays they contributed. And this will demonstrate the breadth of knowledge that goes into this guide. We tried to find, as Trump would say, the best, the experts in every field. And I'll introduce speakers briefly, you know who they are. So first, my good friend, Professor Adam Mossoff. Adam and I have grown close. We took a trip to Israel last year, which is a very special event. He is an expert in intellectual property. And he wrote a outstanding essay on the copyright and patent clause of the Constitution. In fact, Adam said, hey, Josh, I read the essay from the second edition. It could use some work. I was like, huh, do you want to do it? He's like, yes. And that's more or less how it began. I'm not exaggerating too much. Second, my good friend and esteemed colleague, Todd Zawicki. Todd is an expert in the bankruptcy provision of the Constitution, but also the money clauses, which you've probably given no thought before. But the issue of paper money, the issue of whether states can have paper money, this was on the minds of the framers. In fact, they cared more about paper money than they cared about the Commerce Clause or the Due Process Clause or anything else. Those are all like whatever. But this was really an issue that the framers divided over. And the third one is my friend Rob Luther. I've known, oh my God, almost 15 years, maybe more, 20 years. Rob worked in the executive branch, and his job was picking judges. And as you know from Marbury versus Madison, to pick a judge, what do you give him? You give him a commission. And so I asked Rob to write the essay on the commission clause, which if you think about it, is really important. What's the proof that you have the job? What was it William Marbury wanted? He wanted his damn commission. And did he get it? No. So I'll just start because Adam's closest. Adam can go, then Todd, then Rob, but I'll have some questions, some discussion after. So thank you all so much for this honor to be with you today.
5 minutes?
7 or 8.
Okay, yeah. Thank you, Josh. And it was a real honor to be to be invited to be part of this fantastic monograph. I spent a lot of my time researching and writing on the history and the historical understanding of primarily patents, but also copyrights and trademarks and other intellectual property rights as they developed up through the 18th, 19th, and 20th centuries. And so it was a real honor and pleasure to be asked to write the chapter for this book on the what is sometimes referred to as the Copyright and Patent Clause, sometimes referred to as the Intellectual Property Clause, sometimes referred to as the Progress Clause, because it doesn't actually use the words patent and copyright. It uses the term exclusive right. Now, what makes this provision very interesting is that among most law professors and among many jurists and commentators, they almost universally believe that this is a clause that's defined almost entirely by kind of a utilitarian justification, often a Benthamite type utilitarianism, in that the typical influences that we talk about when we talk about the Constitution writ large, John Locke and many of the other the natural rights scholars and thinkers at the time had no impact whatsoever on this clause. And it's very interesting to point out to them sometimes that, well, you do know that Bentham wasn't really writing at the time that the Constitution was written, so that this framing of this clause purely as a utilitarian justified clause where it's just a matter of policy of weighing costs and benefits, economic costs and benefits as to whether we secure the exclusive right to inventors and authors, is anachronistic. And that actually, when you look at the discussions about this provision, there are very few, unfortunately, that they are imbued with the context of the time of the natural rights thinking, social contract thinking, justifications that we are normally see when we read the writing of the founders and the framers when it comes to the founding document of our country. The founders, therefore, as I often point out in my remarks about intellectual property more generally, were innovative not just in politics, but they were innovative about intellectual property. So this was the very first time that the protection of what is patents, which is property rights in new technology and new ways of doing things, and copyrights, the protection of artistic works, was actually put into a country's founding document. It had never been in a founding document before. And it's not an accident that they did not use the term patents and copyrights, which were terms well used and had a long history in England, because they were very much caught up with the notions of royal prerogative power. A patent, for those of you who don't know, was originally derivative of the term letter patent, which was the legal mechanism. It literally meant open letter, following law French of the English courts at the time. And it was a legal mechanism by which the crown acted upon and issued royal grants of privilege, right? So if they had used the word patent in this clause, then it would have been understandable that then this was actually, they were following the British model. This was purely a matter of economic policy being implemented by the crown to advance the interests of the economic interests of the realm. But they didn't do that. Moreover, they put the copyright and patent clause not in Article 1, which would have been following the English model where these were grants from the crown, because Article 1 is our closest analog to the executive, that's the executive, closest analog to the royal power, the English executive. But they put it in Article 2, right? The representatives of the people, the body of our government that is expressly authorized to protect the rights of individuals in their life, liberty, and property. So therefore, there is strong evidence that indicates that they really understood what was going on in England at the time, and they understood to be starting something entirely different. And this is actually confirmed by the follow-on kind of writings that followed out of the convention. Unfortunately, there was no debate on the convention. At the convention, it was the power was proposed, and Madison's notes say it was adopted without debate. That's one line. And so even the language of the clause comes from the Committee on Style. And so the only really official writings that we have on this that are that at the time of the founding and by the framers is in Federalist number 43, Madison's one-paragraph discussion of why this power was delegated to Congress, where he says copyrights have been clearly secured by common law courts as a property right, and by equal reason, the same powers should be conferred upon government to protect inventors, indicating that he thinks the same policy justifications being used by the common law courts to protect copyright also justified patents, and following the long-standing view within kind of Lockean theory and general natural rights moral theories and theories of government, that there is a close connection between the public good or the common good and the good of individuals. That he concludes his remarks in Federalist by saying that the protection of both patents and copyrights is a area where the claims of individuals coincide with the public good. And so very much part and parcel of the thinking at that time that saw the public good as a composite whole of individual goods, individual happiness, individual security of life, liberty, and property, and that the fruits of one's productive labors, and this was language that the early courts used in the early republic and reaching up into the antebellum era, and commentators used, were very much justified not just rights of farmers and their labors to produce crops and the growing manufacturers to make industrial goods, but also justified the inventors and innovators who were driving those farming practices by inventing the mechanized reaper, Charles McCormick in 1836, a very significant patent, inventing, repeating firearms, Samuel Colt's patent on the firearm, and telegraph, Samuel Morse's patent on the telegraph, and so on and so on. And so this is very much part of American exceptionalism. It's very much part of what made America succeed and grow and expand, was that in addition to protecting the rights of farmers and manufacturers and kind of classic long-standing producers, the framers recognized and were very prescient and seeing as a moral matter and as a legal matter that innovators and creators should also have their rights protected to them, and that Congress should be authorized to do so.
Thank you. I want to ask Adam a question. What I really liked about your essay was how you contrast the views of Madison on the one hand and Jefferson the other.
Yeah.
And we often ask, what would the framers think? The framers were not of one mind on IP. And then maybe, I think you say that the Jeffersonian view is more in line with the framers' thought. How do you sort of make that originalist judgment that what is the dominant view when the Constitution is ratified? It's actually a good methodological question for us all to consider.
Yeah, that's excellent. So something I didn't mention in my opening remarks, so that there are founders, not framers, who had contradictory views of intellectual property, and one of them being Thomas Jefferson. So Jefferson actually had a lot of ambivalence, especially about patents. So he, at times, wrote very positively about them. He is recognized as the drafter of the 1793 Patent Act, our second Patent Act. The first Patent Act of 1790 was some of the very first legislation that the first Congress adopted. And at that time, in 1790 through 1793, he wrote very positively about patents. But he then wrote a letter in 1813, which has been cited repeatedly by the modern Supreme Court, was a letter to an inventor, Isaac McPherson, where he refers to patents as being monopolies. In fact, he uses the phrase embarrassing monopolies. And that that we really issue these only because this is the sole way that we can incentivize people to create inventions. And so we should have these be very limited and narrow like we do with other types of monopolies. And so that they're presumptively not valid unless you can show that it was needed to incentivize someone to produce in the first place a new invention. And in fact, Madison and Jefferson actually had an exchange of letters during the Constitutional Convention, where in those letters, Jefferson complained to Madison about the placement of the authorization to Congress of protecting patents and copyrights. And Madison says back to him in these letters at the time in 1788 that this is necessary for ensuring the protection of new inventions and artistic works. And in that letter, he used the term monopoly. And so some people cited that letter by Madison to Jefferson to say, see, the founders thought of these as monopolies, the way because they were monopolies, they were issued by the crown, and we should think of these as monopolies, not property rights. But it's notable that Madison doesn't use the term monopoly in the Federalist. He could have. In fact, he was more than happy to use the term monopoly in many other aspects of his writings and his public writings. So I have interpreted that letter exchange between Madison and Jefferson as him kind of speaking to his interlocutor, Jefferson, by using Jefferson's own terms and terminology to try to persuade him to support the Constitution by saying, okay, fine, if you think these are monopolies, they can still be justified as an incentive. Because his public writings, and therefore the public meaning that he was embracing to try to justify people to vote to adopt the Constitution in the Federalist, and it's consistent with his other public writings, such as a very famous essay he published in 1793 called Property, in a newspaper, where he made it very clear that he believed that property was a broader concept than just tangible objects. And he even says you have property rights in your opinions and in your ideas. And so that's consistent with the very idea that you have property rights in your new ideas of new inventions. So again, the methodology is a public meaning approach, not private meaning approaches, or approaches where you are looking to letters necessarily that people just wrote, where they're arguing with someone whom they disagree with, but are trying to convince them otherwise.
Fascinating. And again, this book will teach you not just the history, but how to do originalism correctly. I think Adam's essay is a good manifestation of that. All right, let me turn to Todd. Todd, you wrote several essays. You wrote on the bankruptcy clause, you wrote on the federal money clause, the state money clause. By the way, we renamed these provisions, and actually they're helpful. They were called the state coinage clause, and Todd convinced me to call it the state money clause. And in fact, I think Adam it was called the patent and copyright clause, and we inverted it, I think, because he said it lines up better with copyright and patent. So Todd, talk about bankruptcy a little bit, but also talk about the state and federal money clause as well. Here's your thoughts.
Well, the founders may have had some disagreement over concepts of intellectual property. They had no disagreement over their revulsion for paper money. They called it pestilence. They called it immoral, right? The whole 9 yards. And what's interesting when you look at these clauses, the various money clauses and the bankruptcy clauses, nowadays we forget why they called the Constitutional Convention. They called the Constitutional Convention for economic reasons. The overarching reasons why they called the Constitutional Convention was the problem of interstate trade barriers to begin with, right? States doing it, but it was broader than that. And it touches on these things. You had an ongoing conflict between farmers and merchants that manifested itself in the idea of populist state legislatures preventing lenders and banks from being able to collect adequately from farmers. You had a problem of states passing different debtor relief laws where a creditor in New York, for example, might get a judgment against a debtor, and then the debtor would just abscond to New Jersey. They'd have to chase to New Jersey and get another judgment because we had no full faith and credit clause, right? You have the problem of international creditors, as we'll talk about in a minute. And so these guys were very concerned about the way in which the, not just interstate commerce that we talk about, but the ability to collect debts across state line, a uniform law on the subject of bankruptcies, creating certain rules to basically deal with these situations, right? And that was the underlying logic of what brought them together in the first place, and we'll talk about some of the particular instances that were triggered by by paper money concerns. Now, some of these concerns will seem very archaic and irrelevant. Like today, for example, they had this concern that the ability of the government to just willy-nilly issue paper money might lead the government to overborrow, run up inflation, things like that. I know it's just crazy to believe that they would think that kind of irresponsibility might result from the government just being able to print paper money.
Go figure.
But it was, some things are always the same. And I'm going to start by talking about money, and then I'll talk briefly about bankruptcy. And so I want to read the particular clauses because getting the language right turns out to be really important here. And there are 4 different concepts that are relevant, that are nested one on top of each other, that are important to understand both in the state money clause and the federal money clause, and why so much of what is allowed nowadays is pretty clearly, in my view, unconstitutional under the original understanding. So let's start off first with the state money clause, because it has a magic term in it that really matters for this discussion. It's not in the federal money clause. So the state money clause, Article 1, Section 10, Clause 1, says no state shall coin money, emit bills of credit. Remember that line, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, right? So you've got coin money, emit bills of credit, make anything but gold or silver a tender, a legal tender, in payment of debts. The federal money clause says Congress shall have the power to coin money, regulate the value thereof, and of foreign coin. Now notice the magic word that's missing there, which is emit bills, 2 things are missing. Emit bills of credit and make anything a tender in payment of debts. So we have 4 terms here that you have to think about that meant something important here that's been all obscured by subsequent history. First, you have coins. It's pretty clear that what they meant by coins were coins minted of specie, say gold or silver, or arguably redeemable in specie, gold or silver, right? Precious metals are coins, right? And there's debate in the Federalist, for example, about mints and all this sort of stuff. One of the first acts they passed in the Federal Union, right? So first you have coins, gold and silver, right? Convertible to gold. So second, there's a concept called treasury bonds. The treasury bond is where the government would borrow, but they were interest-bearing notes that could be originally redeemed for gold and silver. But the government, when they issued a bond, and what we now think of as a treasury bond, when they issue a bond, that pays interest. The third idea were bills of credit, or what they sometimes just refer to as bills. What was a bill of credit? A bill of credit is what we now just call paper money. It was a non-interest bearing issuance by the government that it was intended as a circulating medium of exchange. what we think of as old paper money. The fourth concept is legal tender. And legal tender says the ability to make bills or bills of credit legal tender in payment of debts, both public and private. Now, why does that matter? Because what we'll see is early on, they sometimes issued bills, but the bills could only be used to like pay your taxes. They did not try to make bills legal tender, meaning you could pay private debts. And so when you look on your paper money, if you guys actually carry paper money anymore, I guess it doesn't even say that anymore, right? Legal tender for all debts, public and private, right? So it means you have to accept it for payments of private debt, right? So 4 different terms: coins, bonds, bills of credit, legal tender, right? Now, there it is. Okay, yeah, it's up there on the left underneath there it is underneath the little thing, right? So basically, this is everything that gave the framers nightmares.
Monopoly money.
Right? In fact, Roger Sherman said the Constitutional Convention, I love this phrase, he said the Constitutional Convention was, let's see if I can, was an opportunity to get rid of paper money once and for all, right? It's like, this is our opportunity to, here it is, a favorable crisis for crushing paper money, is what Sherman said at the Constitutional Convention, right? Now, so what was the history here, right? You probably vaguely remember the history. So the basic problem we had was during the colonial era, there were a couple things going on, both kind of legitimate and illegitimate. The legitimate part was there was very little circulating specie in the United States to actually be able to use coins, right? So like British pounds and that sort of thing. That was exacerbated by British mercantilist policies. The whole idea was to bring all the coins back to England, to create a balance of trade where the colonists, when they would actually get their hands on coins, would send coins back to England, right? Pounds and that sort of thing. So you notice the phrase in there where I talk about foreign, to set the value of foreign currency. That's because the low amount of British pounds in the like led to the colonies using foreign coins, like Spanish coins and stuff like that, would circulate as coinage. Those were minted of those sorts of things. So that was a big issue at that time, right? That was kind of a legitimate problem. There's always a shortage of specie. Banks arose, and banks would basically issue paper money, convertible, and stuff like that. But let's set that aside. The bad part is that the colonists just didn't like paying their debts, and so what we saw over and over again was this issuance of paper money to pay debts to foreigners. In particular, was the big problem. So the British actually passed a law called the Currency Act, where they said essentially you can't pay our merchants in your garbage paper money, right? Which created a lot of problems, and originally on. But they basically then were inflating their currency during the colonial era. You get to the Articles of Confederation. The Articles of Confederation gave the central government the sole and exclusive right and power of regulating the alloy and value of coins struck by Congress's own authority, or by that of the respective states. Congress also had the power to coin money and emit bills of credit. And so there, the central government, and it was and the states, the states also had the ability to issue paper money, but not to declare it legal tender. So what happens? They start inflating the currency again, right, to pay off debts. So the big issue then becomes a showdown in Rhode Island. Rhode Island, you get all of these things coming together, right? Who's heard of Shays' Rebellion? Who knows what Shays' Rebellion was about? Right? Everybody knows Shays' Rebellion was really important, but nobody knows what it was about. They thought it was about paper money, right? Basically what happened was Rhode Island, the farmers went to the Rhode Island legislature and said, we want you to issue paper money so we can pay off our debt burdens in paper money rather than in gold, right? Merchants and creditors refused to accept the paper money, so Rhode Island passed a law called the Forcing Act, which declared the bills of credit to be legal tender, right? This is 1786 under the Articles of Confederation still, and levied a heavy fine on those who refused to accept it. The law also said that the merchants had no right to trial by jury or right to appeal a violation of the law. Eventually that was struck down, and no trial by jury. But the response was merchants absconded from Rhode Island rather than accept payment in the paper money. And so then they started applying it, of course, to merchants in other states and said, you have to accept our paper money. What happens then is the states start issuing retaliatory paper money with each other. And eventually, so New Jersey, Pennsylvania, Delaware, and New York, right, led to retaliatory currency laws, right? And so they don't have to take it, right? In Massachusetts then, which refused to do this, this is where Shays' Rebellion broke out, right? Shays' Rebellion broke out was creditors refused to accept payment in farm commodities. The state legislature refused to issue paper money, right? Massachusetts wouldn't go along with what all the other states were doing with paper money. Farmers said, we want you to issue paper money. Massachusetts legislature said, no, that's going to destroy our economy, which is what it did in Rhode Island. So what happened? The farmers rioted, right? Shays' Rebellion was an uprising by the farmers, you know, marching on the Massachusetts state capitol, demanding that they allow paper money, right? August 1786 was the creditors, was Massachusetts. 1786, the paper money riot, known as the Exeter Rebellion, broke out in New Hampshire when they did the same thing, demand that the New Hampshire legislature issue paper money, right? So this is the backdrop, August 1786, September 1786, this is the backdrop to the Constitutional Convention, right? And guess what? Everybody knows, what was the state that boycotted the Constitutional Convention? Rhode Island.
And now you know why.
Why did Rhode Island boycott the Constitutional Convention? Because they thought the convention was going to outlaw paper money, right? That was the big issue as to why Rhode Island boycotted and then refused to ratify the convention because of the Constitutional State Corner Clause. So in August 1786, you get our friends Madison and Jefferson. Madison writes to Jefferson, if the head of the problems plaguing the nation was, quote, the general rage for paper money, unquote, which was producing the same warfare and retaliation among the states as were produced by the state regulations of commerce, right? So paper money was on their mind. They come together, they draft the paper money provisions, and the original then federal paper money provision had 3 elements. It allowed, as we know, the ability to coin money, to regulate the value thereof, and to regulate the value of foreign money. What was absent from that was any mention of emitting bills of credit. And so unlike the state rule, which prohibits an emitting bill of credit, the federal provision is silent on bills of credit. Now, immediately that leads you back to the originalism debate that Josh was talking about, which is if the federal government has a government of enumerated powers, does the silence in that mean they have to actually be given the power to emit bills of credit in order to emit it or not? Later on, the Supreme Court said no. It's just part of the general route by the federal government. But they had a big discussion over this, right? This was the heart of the discussion over the federal money clause, was whether or not the federal government should be given the power to issue bills of credit, right? And then, and none of them thought that the federal government would have the power to issue bills of credit and make it legal tender, right? They thought that in times of crisis, maybe we should allow power to issue, to emit bills of credit, non-interest-bearing notes in order to finance things. But there's no indication that they thought it could be legal tender, right? So Madison said it would be sufficient to prohibit the making bills of credit legal tender rather than denying Congress the power to issue bills completely. Oliver Ellsworth said this was a favorable money to shut and bar the door against paper money. George Reed of Delaware said that if the power to emit bills of credit were not expressly struck out, the words, quote, would be as alarming as the mark of the beast in the book of Revelation.
Oh boy.
Was his view. So by 9-2, the Committee on Style proposal to allow the federal government to emit bills of credit, by 9-2, the convention struck that out. Only Maryland and New Jersey voted in favor of allowing the federal government to issue paper money, right? And the general view you get from this, right? They ended up with silence. They did not specifically prohibit it, but I think the best reading was that they understood that it was not authorized, therefore it was prohibited. They certainly didn't think in any way they were allowing paper money to be declared legal tender, right? And so the big fight on this is, you may remember, the kind of crazy thing involving Civil War greenbacks on the Hepburn versus Griswold in 1870, which held that Congress did not have an implied power to issue paper money under the necessary and proper clause, or to declare legal tender. A year later, literally 1 year later, they flipped in the legal tender clause, overruled that, and said that Congress did have that power after a change in the court. So for those who think that it's unusual for the Supreme Court to overturn precedents, or it's, like it was in the case of Dobbs, they never do this. Well, that time they did it one year apart, simply by changing one of the justices, right? And so that's kind of where it's developed from there. There was a rear guard action. Guys like Stephen Field in the legal tender case has said, if there be anything in the history of the Constitution which can be established with moral certainty, it is that the framers intended to prohibit the issue of legal tender notes both by the general government and by the states, and thus prevent interference with the contracts of private parties, right? And then during the Great Depression, this all went off the rails, right? Let me just say a few words about bankruptcy because it fits with this, right? As I previewed bankruptcy, the real concern there was state debtor relief laws and trying to stick it to creditors in general, creditors of other states, international creditors. So we tend to think today of the bankruptcy clause as being a debtor protection mechanism. It was actually a creditor protection mechanism, right? To provide the sanctity of debt. The Anti-Federalists were really annoyed that this gave the federal government power, right? By making it a federal thing. That meant essentially you could collect debts in federal court. They liked having to come into home cooking state courts, right? That would be good to the farmers. So that was part of what it is. They were upset people would have to travel long distances to deal with this. But the important point here is, if you look at the original understanding, very interesting debate here, and it's actually come back around in the opioid cases. Historically, there was a distinction in bankruptcy law between what was called bankruptcy, which was for merchants. The idea of being merchants take risks, they might be unlucky, they could lose money in an economic venture, and individuals and farmers, right, who were not seen as doing that. It was basically seen as a form of fraud to borrow money and not pay it back. Historically, bankruptcy laws covered merchants under English law. Insolvency laws covered individuals and farms. Bankruptcy laws allowed a discharge of debt. Insolvency laws simply allowed sort of a stay of debt, but it didn't discharge debts. And we know, for example, debtors' prisons persisted in the United States and some states until the 1830s because they didn't do it. Now, how did those two come to be aligned? Fascinating case, Sturgis versus Crowninshield, 1819, classic John Marshall opinion, where Marshall decides the bankruptcy laws, I would say state debtor relief law, decides bankruptcy clause covers, federal bankruptcy clause, covers both bankruptcy and insolvency, and then said that the states had violated the contracts clause by essentially passing this debtor relief law that purported to discharge the debtor, right? So the trick by Marshall was what? In classic Marshallian fashion, I'm gonna dramatically expand the federal government's power to regulate debtor-creditor relations by sweeping everything under it, and then I'm not going to actually decide the case on that. I'm going to decide the case on the contracts clause, right? And so that kind of skated by after, and if you read the history on this, everybody sees it as a pivotal contracts clause case, but they don't realize that Marshall also did a big bankruptcy case. The final thing I'll say then is this issue is percolated for a long time, but it finally became relevant during the opioid cases a few years ago. In the opioid case involving pharmaceutical, the owners of the company who did not file bankruptcy proposed that they're going to send like $5 million to the bankruptcy estate, and in exchange the bankruptcy court would stay private actions against them as individuals, which they usually wouldn't be able to. Now, My argument was that is unconstitutional because the bankruptcy clause only gives power to reallocate things between debtors and creditors, not third parties. Supreme Court agreed with me, not on originalist grounds, a little bit, but that issue surprisingly came up much later on, right? Which is what is the jurisdiction of the bankruptcy clause, and they held in that case that the bankruptcy clause jurisdiction of Congress does not extend to third parties who are not debtors and creditors, essentially.
All right, Todd, let me ask you one question quickly
Okay.
before I go to Rob. You mentioned briefly the gold clause cases. This was during the New Deal.
Yeah.
Before the New Deal, money said can be redeemable for gold. So if you go to any treasury, they give you gold for it. FDR said we're not going to do it. And FDR said if the Supreme Court rules against us, it will cause a global economic depression. Sound familiar? In the current tariff litigation, the Trump administration said that if they rule against the Trump on tariffs, it will cause a global economic crisis. Todd, discuss.
Quickly.
Yeah, right, and this is how they've basically eroded. This is how they've basically eroded all of these constitutional provisions. All these economic constitutional provisions have, and this is the golden rule of destroying a constitution, right? Which is make exceptions during emergencies that never get undone, right? And so every one of these, right? What led to the unraveling of the coinage clauses and these things was first the Civil War, then the Great Depression, right? And this need for necessity and the difficulty of unscrambling the egg. And so this is kind of where we're at. And so even the strongest originalist, I remember maybe Scalia gave this as the example, which is he said something like, you probably know the quote better, obviously paper money is unconstitutional, but I'm a faint-hearted originalist. Obviously, I'm not going to get rid of paper money because of the disruption that would be caused by it, right? But the big point here is that these exceptions, and particularly these exceptions on these economic things, right, go one way, right? They lead to an expansion of federal power, and unless the court is going to undo it promptly, which they could have done in the 1870s in the legal tender cases, right? Then you just open up the door to further and further expansions. And what do we see the way that monetary policy works in this country now? Every boom begets the next bust, which begets the next emergency, which begets the next boom, right? On these sorts of things. And so we just keep digging deeper and deeper and deeper holes by making more and more exceptions every time to respond to the problems we created by the last time we made the exceptions.
Very good. All right, Rob, commissions clause, please. Let's share your thoughts.
All right. Thanks, Professor Blackman, for inviting me to write for the book and for this event here today, and thanks to all of you for making time to come and see us. The commissions clause is found in Article 2 because it relates to the powers of the executive. It's the last clause of Section 3, and it reads, "The President shall commission all the officers of the United States." Now, the Constitution itself does not define commission, but it is well described in founding area dictionaries. John Kersey's Dictionarium Anglo-Britannicum from 1736 defines commission as a warrant for an office, a charge to buy, or to do an act for another. While Samuel Johnson's Dictionary of the English Language of 1755 defines it as a trust, a warrant by which trust is held, or authority exercised. So those definitions in tandem cover the two essential elements of a commission, which are the conceptual grant of power conferred by an executive, the president, to one of his agents, authorizing him to exercise authority in the president's name. That grant or charge of power is then conferred to a physical written document signed by the president, which evidences his appointment. It typically starts off something to the effect of to whom all these presents greetings. That's the physical commission. So today I'm going to talk about two issues: who the president commissions, and when the president issues those commissions, he decides to appoint. So who does the president commission? From the outset of the Republic, the commissioning process was diligently executed. For example, on September 11th, 1789, President Washington nominated Alexander Hamilton to serve as Secretary of the Treasury. The Senate confirmed him, and Washington issued him a commission. 2 weeks later, Washington nominates John Jay to serve as Chief Justice of the Supreme Court. The Senate confirms him, and Washington signs a commission that he puts in the mail to Jay. A few years later, Marbury versus Madison, Chief Justice Marshall recognizes that the Constitution requires the President to commission all the officers of the United States. However, later in the opinion, he observes that that may not have been applied to all officers appointed by individuals other than himself. So while the President commissions cabinet secretaries and justices, Marbury seems to leave open the possibility that not all inferior officers need commissions by the President of the United States. And that contemporary question remains, even though the text of the Constitution says that the President shall commission all the officers of the United States. Now, there is some historical evidence from that era that not all officers were in fact commissioned by the President of the United States. One example is the clerk of the U.S. Supreme Court. Now, I'm not really sure why the President would have been commissioning the clerk of a different branch of government, Article III, who isn't in fact a judge, but apparently this was a notable exception at the time that Chief Justice Marshall referenced. The modern DOJ has also taken a less formalistic view on commissions. The Office of Legal Counsel, OLC, at DOJ has recently observed that although the holder of an office usually receives a commission, that characteristic, like an oath or pay, is incidental rather than essential. Finally, for fans of recess appointments in the room, you may be wondering, does a recess appointee receive a commission? Yes, of course, because that individual is not confirmed with the advice and consent of the Senate. That's the only evidence of the recess appointee's appointment itself. So our second question, when does the President issue a commission? The President can commission a principal officer of the United States only after the Senate provides advice and consent. After the Senate has provided advice and consent, the President signs the commission, and upon doing so, the appointment is complete. This process is the same for executive branch officials as well as for federal judges. Presidential appointments of a principal officer follow a three-step process. The President submits the nomination to the Senate provides advice and consent, and the President appoints the officer. The third step is completed when the President signs the commission. Now, we have a fairly unusual modern example of a recent appointee to the U.S. Supreme Court who was commissioned in an odd way that I want to comment on here today. In January of 2022, Justice Stephen Breyer announced that he intended to retire, quote, when the court rises for the summer recess, assuming that by then my successor has been nominated and confirmed. President Biden nominated Judge Ketanji Brown Jackson to that seat, and she was confirmed on April 7th, 2022. Biden then signed her commission the next day, on April 8th, 2022, despite the fact that Justice Breyer is still serving and continuing to serve on the Supreme Court for the next 3 months. So, some people noticed this, and consequently, President Biden's Office of Legal Counsel and the Department of Justice authored an opinion entitled Authority of the President to Prospectively Appoint a Supreme Court Justice, which stated that the President has, quote, appointment authority at the time a vacancy is expected to arise, and therefore may perform in advance the last act in the three-step appointment process, that last act being signing the commission. As a result, OLC reasoned that the President may commission an officer well before the officer is actually appointed. Now that doesn't make a lot of sense to me, because the commission is what gives legal effect to the President's appointment. Now, to its credit, the OLC opinion identified several examples of judges who were appointed by the President prior to the effective date of the outgoing judge's resignation. And indeed, it did. Yet this strikes me as clearly wrong, both as a matter of founding era practice and, well, modern logic. Now, the Trump administration that I served in was before the Biden administration, and before that Biden administration OLC opinion. And when you take a job like that, you swear an oath to uphold the Constitution, but you also don't want to do things that expose your nominees to unnecessary political risks. I can tell you that our practice was not to commission officers until after the Senate confirmed them and after a seat opened up for them to be seated into. From memory, we had at least 2 instances where we actually had to exercise this judgment. I'll give you those examples. May 7th, 2018, Judge Marvin Quattlebaum was nominated to a seat on the U.S. Court of Appeals for the Fourth Circuit to take a seat that was currently occupied by Judge Bill Traxler, who informed the President that he would assume senior status on August 31st, 2018. Although the Senate confirmed Judge Quattlebaum on August 16th, 2018, 15 days before the seat opened, we asked the Staff Secretary's office to hold the commission, to hold the President signing the commission until after Judge Traxler went senior on August 31st, and we then had the President sign the commission on September 4th, 5 days after Judge Traxler vacated the seat. Similarly, on May 4th, 2020, Judge Justin Walker was nominated to a seat on the D.C. Circuit. Judge Tom Griffith had occupied that seat and sent a letter to the President saying that he would retire effective September 1st, 2020. Now, although the Senate confirmed Judge Walker on June 18th, 2020, over 2 months before the seat opened, the President did not sign Judge Walker's commission until September 2nd, 2020, the day after Judge Griffith retired. Now, the Biden OLC opinion says that President Trump could have commissioned those judges before the judge they replaced left their courts. And again, while there are historical examples where that happened, it's not consistent with the practice of the founding, and it's certainly not good practice today to expose the President's nominees and judges to disqualification suits because they weren't properly appointed. Federal statute limits the number of judges that sit on federal courts. The federal statute also limits the number of Supreme Court justices to 9 members. So my question is, did the United States briefly have a Supreme Court composed of 10 active justices? Did Justice Jackson draw the salary of Supreme Court justice for the many months before Justice Breyer vacated his seat? What if Justice Breyer had withdrawn his retirement letter? I've heard through the D.C. rumor mill that Justice Jackson was issued a second commission after Justice Breyer actually left the court. Now that's all over now. Justice Jackson obviously didn't hear any cases while Justice Breyer was still on the court, but formalism in the law matters. Now, I've got a situation that hasn't happened yet, but could. I want you to think about it. Could a president preemptively nominate...
Oh, that was my question.
Well,
Good. That was my question. Go for it, Rob.
Could a president preemptively nominate commission replacements for members of the Supreme Court and lower courts? Would stockpiled commissions effectively finalize an appointment as soon as the vacancy arises? Biden's OLC relied on the judge's retirement letter as the triggering event. But retirement letters aren't constitutionally required and can be withdrawn. In fact, we just saw 3 of them withdrawn by 3 Democratic appointed judges who mysteriously withdrew them after President Trump was reelected in 2024. Judicial misconduct complaints were filed against those 3 judges for engaging in political activity in violation of Canon 5 of the Judicial Code of Conduct because they withdrew retirement letters immediately following a political event, the election of a president of the opposite party. Now, those complaints were filed 9 months ago, and they were referred to the Second Circuit's Judicial Council. It's the Judicial Council where Judge Menashe sits, and those cases are still pending, and I have not heard that they've been resolved, which leads me to believe that they are being taken very seriously. Now, the takeaway is that the political reality may be the only thing preventing judges from being prospectively appointed. So the political realities of the Senate may be the only obstacle in the way here. So I'll leave you with this question. How many senators from one party or the other would be necessary for the Senate to have the political will to start confirming and appointing judges or justices while the Supreme Court still has 9 active members and where there are no other judicial vacancies on the lower courts? I'll leave you with that question.
All right. Thank you so much. Questions from the audience? Yes, go ahead.
What is the legal significance of the Office of
question.
on the law? Is it just an explanation so they don't look crazy, or?
You mean the OLC opinion?
Yes.
What that-
Is there, what is this, like, is there any binding weight for anything with that, or is it just what their theory is? For
Well,
what
that's an
they're doing?
excellent and sophisticated question. You know, OLC's nickname is the law firm to the presidency. And, you know, the White House counsel's office is a small office, sort of in a military hierarchy, I kind of call them the generals. And, you know, OLC might be like one branch of military, maybe Army or the Navy. You know, we don't have the resources to do heavy lifting on a lot of stuff because we're kind of making a lot of quick decisions. So we come up with questions and rely on other people to give us advice so that we can consider the political valence and weigh that with the legal arguments and then, you know, recommend a decision to the White House counsel and the president. So there is no, you're not binding, you know, the OLC does not bind the White House. OLC services the White House. OLC reports to the White House. And under the unitary executive theory, the president, White House counsel, attorney general, the assistant attorney generals at DOJ, you know, they would interface probably with one of the deputy White House counsels on answering these questions. We can seek advice. If we don't like the advice we get, we don't have to take it.
Presumably, though, the White House counsel asked the Attorney General, we then asked the OLC formally, is that right? The OLC
It's not,
reports
it's,
directly to the White House or
well,
to the Attorney General?
it's not, the White House counsel could ask the Assistant Attorney General, the Senate confirmed individual in charge of the Office of Legal Counsel directly. You don't need to go formally through the chain of the Attorney General and the Deputy Attorney General. The counsel of the President, assuming, you know, he's empowered, could ask the Assistant Attorney General directly to render those decisions.
I'll just add, to plug the Constitution, something called the Opinions Clause, where the Constitution gives the President the authority to ask the members of his administration for opinions on different legal issues, and that's sort of the basis of what OLC does.
Right, the White House counsel is a staff position, you're not confirmed by the Senate, it's typically a lower profile person. They render advice as a lawyer would to the president so that he can exercise his constitutional duties. You know, the White House counsel is not the chief law enforcement officer, that's the Attorney General.
All right, what other questions we have? Yes?
If the validity of Justice Jackson's appointment were challenged, would she be saved by the second commission?
Yes, there's also a doctrine in federal courts called the de facto officer doctrine, which essentially immunizes people acting in positions of authority from, you know, the kind of suits that you're probably thinking that would render all their prior judgments invalid and so forth. And you know, there have been some other weird judicial appointments. We cite some of them in the essay that you can check out if you're interested, where that doctrine saves some sort of fake judges.
I'll give you another example from another clause, like the ineligibility clause. It says that a member of Congress cannot be appointed to an office for which a salary was increased during his time in Congress. Okay? Senator Hugo Black was a member of Congress. He voted to increase basically I'm going to be careful here, the pension for Supreme Court justices. He was then appointed by FDR to the Supreme Court during the term for which he raised the salary. And on the first day that Hugo Black came to the Supreme Court, a member of the bar raised his hand. They said, "Mr. Chief Justice, I object. Senator Black and Justice Black is ineligible." And the Supreme Court basically said, "There's no standing to bring a claim, go away." So arguably, Justice Black served for more than 3 decades in violation of the Constitution, arguably. Will Bode is a really fascinating article in the Texas Law Review. But if you read the eligibility clause, that's it, you learn so much. There's a question in the back somewhere. So, yeah, in the back.
So my question is for Professor Zawicki about the money clauses. So the state money clause says they can't make anything but gold and silver coin. And the federal money clause says 2-coin money. Does that imply the money that the federal government coins has to be either gold or silver? Or can they make it out of other materials?
That implies that the money the government makes has to be gold or silver. Or they can issue bonds, which are interest-bearing things. That's basically related to debt rather than this. But it implies that, yes, they would have to either be minted of coin or arguably redeemable in coin. Now, what ended up happening was during most of the 19th century, as some of you may know, the government didn't issue money. Money was issued by private banks, backed by convertibility into gold and silver at the banks, or backed by interest-bearing treasury bonds. So that would imply that what the government could do was simply to coin money. Utah floated a proposal a few years ago for the state to coin some gold coins, consistent with the state coins clause, but I don't think it ever went anywhere. One of the arguments that one of the discussions that you see in Federalist 44 and 42 is some concern about the redundancy of mints, and arguments on what the state should be able to do and that sort of thing. There's a question about whether states should be able to issue money at all. Was one of the debates that they had.
All right, maybe one more question here, right over here. Yeah, you.
Also to Professor Zolwicki, you made the point that in times of crisis, institutions and practices that are pretty blatantly unconstitutional tend to come into being, but they also do become relied upon subsequently, such that there would be massive practical obstacles to something like removing paper money. So when it comes to those sorts of blatantly unconstitutional things, what practical options are there for sort of moving back toward a constitutional view, or is it just the damage is done?
Yeah, I mean, we saw this during the financial crisis in 2008, for example, all kind of illegal activity, right? But it is kind of one of these things where, you have to ask your question, what's the purpose of a constitution? Why have a constitution? The only time a constitution really matters is during a time of crisis, right? That's the only time where people are tempted to cut corners and skip over the rule of law. And so really it comes down to the question of, do you want to have a constitution or not, right? You can have a constitution because there's very few examples, certainly in the economic realm, right? Maybe in individual liberties or something. There's very few examples where the government seizes emergency economic powers that are extra constitutional and then gives it back, right? The New Deal being the obvious example of overrunning the Commerce Clause, overrunning the money clauses, overrunning property rights, all these sorts of things. And then they make these arguments about reliance. And so, they made this argument, as Josh said, right? The tariff arguments are going to destroy the global economy. Obama, they made these arguments during the financial crisis, right? That we have to be able to do all these things to save the global economy, right? And the politicians are always tempted to give in or want to do it during the crisis. And so it really comes down to that fundamental question, which is constitutions exist to pre-commit the government to doing certain things or not doing certain things, right? What that's supposed to mean is that the government is careful about not putting themselves in that position in the first place, right? That the government pre-plans, anticipates, right? So that they're not left, and bank bailouts have turned out to be a classic example, right? Which is nobody believes that we're not going to bail out banks. And so banks act like we're going to bail them out, right? If we want to be serious about preserving constitutional structure, we have to create structures so that we're never in the position where we're tempted to overrun them, right? Whatever that might look like.
All right, thank you all so much. And we'll start our Bernstein Lund out there. All right, we'll take just a 2-minute pause, and then we'll resume. Thank you so much.
You're going to be at the